So, in the Supreme Court, the battle for the fate of free speech in America is in full swing. There are 3 cases worth noting here. The first 2 involve Florida and Texas, who have passed new laws aimed at ending corrupt social media platforms from blatantly culling speech. These new laws in Texas and in Florida have sought to restrict social media platforms from moderating content based on political views, which has led to legal challenges from the tech industry groups. These groups are arguing that such laws infringe on the platform's First Amendment rights, which then takes us to Section 230, the legal framework for internet content immunity. As it stands now, in Section 230, it provides immunity for online services like social media platforms from liability for third-party content, meaning what you post, they're not liable for. A key provision of 230 prevents providers and users of an interactive computer service from being treated as the publisher or speaker of third-party information. Now, so far so good, right? But then we come up to the Good Samaritan protection part of the Section 230. This offers protection from civil liability for the removal or moderation of third-party material that they deem objectionable in good faith. And this is where the problem really arises. This means that while the government cannot compel these companies to censor or promote certain speech, the platforms themselves have the discretion to manage content according to their policies. Now, this may have seemed like a good idea at first, but it has allowed the social media giants to crush millions of citizens' abilities to actually practice free speech. And I get it. The argument is that free speech doesn't really apply here when we're talking about social media platforms. But the reality is social media has become the public square that people use almost exclusively to share their ideas. Allowing these massive corporations to effectively control the speech of hundreds of millions of people with impunity is abhorrent. And as we have already seen, will lead us directly towards corporate fascism, which we'll discuss further in a moment when we get to the second, or rather third case at the Supreme Court, which is dealing directly with the government pushing and coercing social media platforms towards censoring information that the government doesn't want discussed or seen. But we'll get to that in a moment. For now, let's stay focused on the Texas and Florida cases. The central issue here, specifically Net Choice versus Paxton, which is the Texas case, and Moody versus Net Choice, the Florida case, are examining whether states can regulate social media platforms as common carriers to prevent them from moderating content based on political viewpoints. The concept of common carriers traditionally has applied to entities that provide public transportation or communication services and are required to serve all customers without discrimination, like telephone companies, because they provide essential communication services to the public. Now, this designation subjects them to more stringent regulation due to their importance in serving the public interest. Texas and Florida are arguing that social media platforms function similarly to traditional common carriers, which that sounds right to me, but what do I know, right? Anyway, they are contending that these platforms should be subject to regulations that prevent them from discriminating against users or viewpoints. But the fears of the anti-free speech advocates are this. If social media companies were classified as common carriers, they would be unable to moderate content, potentially leading to a surge of objectionable material on their sites, which, to be frank, pales in comparison to the Orwellian nightmare that is censorship in general. Loss of the ability to speak freely will almost certainly inevitably guide our nation into tyranny. We have already seen the growing evil from dictatorial governments who have reveled in the newfound freedom of secrecy brought on by this latest purge of free speech. This sort of thing needs to be stamped out, not encouraged. So the question then arises, well, where does it seem like the court might land here? Well, according to far-left online news outlets like Vox, they say that the Supreme Court appeared lost in a massive case about free speech online. The justices look likely to reinstate Texas and Florida laws that seize control of much of the internet, but not for long. These laws advocates are quite proud of the fact that they were enacted to prevent moderation of conservative speech online, even if the big 3 platforms deem some of that content, such as insurrectionist or anti-vax content, offensive or harmful. Florida Governor Ron DeSantis has said that his state's law exists to fight supposedly biased silencing of our freedom of speech as conservatives by the big tech oligarchs in Silicon Valley. And Texas Governor Greg Abbott has said that his state's law targets a dangerous movement by social media companies to silence conservative viewpoints and ideas. But Vox went on to point out that at least 5 justices, Chief Justice John Roberts, plus Justices Sonia Sotomayor, Elena Kagan, Brett Kavanaugh, and Amy Coney Barrett, all seem to agree that the First Amendment does not permit this kind of government takeover of social media moderation. There was a long line of Supreme Court cases stretching back to 1974 holding that the government may not force newspapers and the like to publish content that they do not wish to publish, and these 5 justices appeared to believe that cases like this should also apply to social media companies. And Vox went on to say that indeed, some of them seemed so appalled by Florida's and Texas's attempts to control speech online that at times they seemed to mock the lawyers defending those states' laws. As Roberts asked Henry Whitaker, Florida's Solicitor General, is there any aspect of social media that you think is protected by the First Amendment? But see, here's the rub. These social media platforms are not really publishing content or editorializing like newspapers do. This would have granted them the First Amendment protection, sure. But instead, these websites are merely hosting content. We, the users, are the ones publishing. As Florida Solicitor General Henry Whitaker told the justices on Monday, he said the platforms do not have a First Amendment right to apply their censorship policies in an inconsistent manner and to censor and deplatform certain users. Now, NPR also weighed in on this matter when answering the question about what the justices might decide here. They said that the justices will have to decide between radically different conceptions of what social media is. Are these platforms more like old-time phone companies, basically open to everyone without filtering, or are they more like bookstores and newspapers, places that edit and curate information that get the highest level of First Amendment protection? Now, to me, just a man on the internet and someone who has been content creating for quite some time now, it seems patently obvious that these social media platforms should never be allowed to censor information. It is a critical and necessary tool for the citizens of this country to have free access to social medias. This is how we communicate now. We don't go to public squares like we used to. This is where people talk. And indeed, even Justice Clarence Thomas has previously suggested that digital platforms, due to their control over the flow of information, might be akin to regulated entities like telephone networks, which has influenced the arguments in these cases. And the outcomes here may very well shape the future in how social media platforms are regulated and their ability to moderate content on their websites. And why this matters so much is as it stands now, the government has already figured out how to use this loophole of Section 230 in allowing social media giants to censor their users for their own benefit. Which then brings us to the third pressing court case being seen by the Supreme Court, which is Murphy versus Missouri. This case arose from efforts during the early months of the Biden administration to encourage and coerce social media platforms to take down posts spreading so-called misinformation about COVID-19 and the 2020 presidential election. The case involves claims by the states of Missouri and Louisiana, along with several social media users, that federal government officials in the Biden administration violated the First Amendment by engaging in what the plaintiffs describe as a sprawling censorship enterprise. The plaintiffs are arguing that the administration's effort to suppress misinformation, particularly regarding COVID-19 and the 2020 presidential election, crossed the line from public health education to censorship by proxy. The central issue here, my friends, is whether the Biden administration's efforts constituted a violation of the First Amendment's free speech. Did the government's communications with social media companies amount to illegal attempts to informally censor speech on these platforms, thereby infringing on the expressive rights of the platforms and their users? The arguments are centering around the distinction between permissible government persuasion and impermissible coercion of private companies in content moderation decisions. Here is a sample of the discussion between Supreme Court Justice Alito and Brian Fletcher, who is the U.S. Principal Deputy Solicitor General. Take a look.
Exchanged between the White House and other federal officials and Facebook in particular, but also some of the other platforms. And I see that the White House and federal officials are repeatedly saying that Facebook and the federal government should be partners. We're on the same team. Officials are demanding answers. I want an answer. I want it right away. When they're unhappy, they They curse them out. There are regular meetings. There is constant pestering of Facebook and some of the other platforms, and they want to have regular meetings. And they suggest, they suggest rules that should be applied, and why don't you tell us everything that you're going to do so we can help you and we can look it over. And I thought, wow, I cannot imagine federal officials taking that approach to the print media, our representatives over there. If you did that to them, what do you think the reaction would be? And so I thought, the only reason why this is taking place is because the federal government has got Section 230 and antitrust in its pocket, and it's, to mix my metaphors, and it's got these big clubs available to it. And so it's treating Facebook and these other platforms like they're subordinates. Would you do that to the New York Times or the Wall Street Journal or the Associated Press or any other big newspaper or wire service?
So there's a lot packed in there. I want to give you one very specific answer first and then step back out to the broader context. So specifically, you mentioned demanding an answer right away and cursing them out. The only time that happens is in an email that's about the president's own Instagram account. It's not about moderating other people's
Okay, we'll put that aside. There's all the rest. Constant meetings, constant emails. We want answers. Right. We're partners. We're on the same team. Do you think that the print media regards themselves as being on the same team as the federal government, partners with the federal government?
So potentially in the context of an effort to get Americans vaccinated during a once-in-a-lifetime pandemic. And I really think that piece of context, it doesn't change the First Amendment principles, but it's relevant to how they apply here. And I think it's important to understand that at this time, this was a time when thousands of Americans were still dying every week, and there was a hope that getting everyone vaccinated could stop the pandemic. And there was a concern that Americans were getting their news about the vaccine from these platforms, and the platforms were promoting, not just posting, but promoting bad information.
I understand all that, and I know the objectives were good. But once again, they were also getting their news from the print media and the broadcast media and cable media, and I just can't imagine the federal government doing that to them. But maybe I'm naive. Maybe that goes on behind the scenes. I don't know, but it struck me as, wow, this is not what I understand the relationship to be. That's all.
I do. I think this is important because I have the same reaction that you do, that these emails look unusual. I think the idea that there'd be back and forth between the government and the media isn't unusual at all. When the White House press secretary on July 16th is asked about this by the press at the time, what she says is, of course we talk to the platforms just the way we talk to all of you when we have concerns about what you're doing, when we have information that you might find helpful. Now, there's an intensity of the back and forth here, and there's an anger that I think is unusual, but the context for that, I think, is that these platforms were saying publicly, we want to help. We think we have a responsibility to give people accurate information and not bad information, and we're doing everything we can to meet that goal. That's where this language of partnership comes from. It's not just from the White House. It's these platforms, which are powerful, sophisticated entities, saying we're doing the best we can. And the anger, I think really most of the anger when you read the emails, and I appreciate that you have because I think you have to look at them in context, the anger is when the officials think that the platforms are not being transparent about the scope of the problem or aren't giving information that's available.
Now you caught that, right? Once in a lifetime. Well, that's what they always say. And it doesn't stop there. You got to listen to this. This is unbelievable.
Justice Jackson?
So my biggest concern is that your view has the First Amendment hamstringing the government in significant ways in the most important time periods. What would you have the government do? I've heard you say a couple times that the government can post its own speech, but in my hypothetical, kids, this is not safe, don't do it, is not going to get it done. And so I guess some might say that the government actually has a duty to take steps to protect the citizens of this country, and you seem to be suggesting that that duty cannot manifest itself in the government encouraging or even pressuring platforms to take down harmful information. So can you help me? Because I'm really worried about that because you've got the First Amendment operating in an environment of threatening circumstances from the government's perspective, and you're saying that the government can't interact with the source of those problems.
And, Your Honor, I understand that instinct, and I guess what I tell you is
It is unbelievable that a sitting Supreme Court justice is actually complaining about the government being restricted from steamrolling citizens' rights during an emergency. Yes, that is the purpose of our rights in this country. It is sole purpose, in fact, is to hamstring the government. It is to protect us from them. The government is there to serve us, not the other way around. The modern-day left has long since complained about our Bill of Rights, going so far as to call it a negative Bill of Rights because it doesn't stipulate what the government can do to you, but rather only what it cannot. Once you allow suspension of rights because of so-called emergencies, the government will always then find a way for there to be emergencies that require us good little citizens to just give up our freedoms. This is precisely how you end up in a totalitarian regime, where the citizens are crushed under the boots of their betters. If you had asked me 10 years ago if we would be sitting here now today on the precipice of watching our most basic fundamental rights like free speech disappear forever, I don't think I would have believed you. But the inexorable move towards stripping U.S. citizens of their freedom is moving fast now. And if we aren't careful, you might just blink and wake up and find yourself in a country you do not recognize anymore, with a government ruling over you with a complete disregard for you as the individual. It will always be about the greater good. Individual be damned. And indeed, free speech groups, tech companies, and other stakeholders are closely watching this case, as the Supreme Court's ruling could redefine the boundaries of government coercion on private speech and impact the fight against misinformation online. A decision in this case is likely to be issued by the end of June of 2024, which will clarify the extent to which the government can engage with social media platforms to address misinformation without infringing on constitutional free speech rights. And let's hope that sane opinions from the last bulwark against tyranny remain supreme here. And that, my friends, will bring our episode to a close once more. From the To Be Frank show, I am Adrian. Thanks for watching. I'll see you all next time.